Hello everyone in the Ansakari, and today we are going to discuss the set of questions on the topic that is the center and the state relations, which we have covered in various previous videos where we talked about what is federalism, the type of federalism in India, the difference with the other popular democracies and the countries across the world. Then we categorized the relations in three types, that is the admin relations, financial relations, and legislative relations. We talked in detail about the residuary powers, and on the basis of all the information which we have gathered, today we are trying to use that knowledge to give the answers of the questions which have been posted here. So, in a brief, we can consider this box which is telling about the borrowing powers and as a reference. So union government borrows under Article 292 on the consolidated fund, and state governments in Article 293 on the consolidated fund of state. The union can borrow from within and from the outside of India, but the state can borrow from sources only within India and again with the permission of the central government. यूनियन एज आई मेंशन कंसोलिडेटेड फंड ऑफ स्टेट कंसोलिडेटेड फंड ऑफ इंडिया के अंदर जो सिक्योरिटीज हैं ऑन द बेसिस ऑफ देम दे टेक्स लोन एंड द लिमिट्स is decided by the respective legislature, that is the parliament at the central level and state assembly on the state legislature level. Then there is no as such limit over the borrowing on the central government, but we have a limit that is duly decided by the Parliament of India under Article 293 Clause 3, which provisioned the power of Parliament and particularly the Union government the time the state is going to borrow the financial amount from the country via various methods. So the very first question we have is discuss the administrative relations between the center and the states in the light of the recent controversies. So the administrative relations, we can say that regarding the control of administrative agencies. For an example, the All India Services, that is the IAS, IPS and IFS. इनके कंट्रोल के ऊपर सेंटर और स्टेट्स के बीच में आपस में इशू रहते हैं, इनके कैडर के ऊपर चैलेंज रहते हैं, इनके ट्रांसफर के ऊपर इशू रहता है. Prominent example, if we talk about the contemporary times, so we have the case of Delhi, where even though the Delhi is considered as a UT which is under the direct control of the central government, here also the officers were challenging the elected government by not implementing the tasks which were assigned to them. Again, we have the allegations and the cases of allegations between the top-notch elected authority, that is the CM and the cabinet, by the top grade officers like chief secretaries for the abusive language allegations and the allegations for also using direct attack. Second example we can take in the relations regarding the West Bengal, where the police commissioner of the Calcutta city was present on the political march, also was assisting the chief minister during her political speech. So that was alleged that he is surpassing his conduct rules and was called back to Delhi to give the explanation for such. But the state government protected that officer. The second instance came when the Prime Minister of India was visiting in the state of West Bengal. And according to the administrative convention, whenever the governor, whenever the Prime Minister, the president reaches out to the state, it is the responsibility of the officers ranging from sub-divisional magistrate to the DGP and cabinet secretary, chief secretary, to represent the state in the front of Prime Minister. But at that time also, the officer was absent, the chief secretary was absent from the formal meeting of the Prime Minister. Then he was also called back to Delhi, but he was not released by the state government. And then finally we saw that on the administrative relations and particularly on the services, a stringent rule was made by the central government where the officers needs to adhere to the cadre policies and to the conduct rules, and a minimum tenure of 3 years for every officer will be there in the central deputation and 6 years in their respective cadres. Apart from that, if we talk about the administrative relations, is the use of power, the administrative power by the governor and the lieutenant governor. Example, Kerala over the university chancellor post. That is the administrative matter. Tamil Nadu example, Governor R.N. Ravi, who was former the governor of Nagaland. So administrative control over universities, administrative control over the administrative agencies, administrative control over the tribal councils in the tribal or in the scheduled areas. So these are some administrative conflict of interest between the elected government and the appointed governors at the state level, which becomes an issue of center and state relations. Apart from that, there are some areas where the administration is run by the governor, not by the uh, elected government. Example, we can take of the contemporary times when the Union Home Ministry, specifically in the context of Article 239 AA, which deals with the Delhi and the administration of Delhi NCR region. Now the government nomenclature is used for the lieutenant governor, not for the elected government. So such kind of issues have been laid out in various courts, like the case is going on in the Supreme Court of India, Delhi versus Union. So these are the prominent examples where the administrative relations have been strained between the center and the state government. Apart from that, Oshik and Mansi can provide an insight on this question.
ठीक है प्रभुष ऐसे
Okay. So the second question we have is the constitutional mechanisms to resolve the interstate water disputes have failed to address and solve the problems. Is a failure due to the structural or the process inadequacy or both? Discuss. So I will say that it is not the constitutional mechanisms which have failed, but we are witnessing the lack of political will, which is limiting and which is limiting the efforts of the constitutional mechanism, which provides for peaceful arbitration as far as the interstate water disputes is concerned. Example, in the constitution under Article 262, it is clearly mentioned in the constitution that whenever there is an interstate water dispute, an interstate water tribunal will be established, and subsequently in 1956 via the State Reorganization Act, the interstate river tribunal was established on the union level to decide the disputes over the river valleys and the river drainage and river control between various states. Apart from that, timely, because the parliament is a competent power where even the judicial intervention is not allowed in interstate water disputes, parliament has timely incorporated the demands of various states, both upper riparian and lower riparian states. Example, Krishna Water Tribunal. Example, Kaveri Water Tribunal. Example, Godavari Water Tribunal. On the basis of these tribunals, we have seen that the equitable sharing formula and the proportionality principle, which is mentioned in Constitution, have been used by the Parliament to provide the equitable sharing of river to both the riparian states and in the interest of the common citizen of people. Now, is this a failure due to structural or process inadequacy? So we can say that yes, there are some issues. For an example, politicization of the water. Example, currently we can say the Kaveri Pet, the Bangalore water crisis. Number two, there is a need for the structural strengthening of water services. So the already
मैं कर दे
so
स्टार्ट कर दे
we were talking on the interstate water dispute, and we have seen that what we can do and what we cannot do. Third question is, the states in India seem reluctant to empower the urban local bodies both functionally as well as financially. So we cannot completely agree with this statement that states are reluctant uh, to empower the urban local bodies, because at the central level, at the state level, we are also seeing that how the digitization wave of Panchayati Raj institution has been taking place. The Finance Commission, both the 14th, 15th, and 16th Finance Commission have clearly established the financial devolution principle for the Panchayati Raj system so that they can function in an efficient manner. Apart from that, we are seeing today that there is a social engineering which is happening via the education method, via the capacity building, because of which the top to bottom up approach governance has been taking place. Example we talked while discussing about the panchayats. But yes, there are some issues which are there. Number one, there is a politicization at the intermediate and at the district level panchayat. Number two, the finances which have been granted, there is a very less autonomy to the panchayats to use them because they are very specified fund. So they have to use according to the direction given from the district level, from the intermediate level. Number third, we see that functions which have been assigned to the panchayats, it is not that state is not providing them enough power. We can also say that panchayats themselves are not able to effectively use those functions. As far as we can take the example of taxation, the panchayats are reluctant in tax appropriation, in tax levy, in tax collection, because of which they have to demand grants, they have to wait for the finance from the state governments. So, despite all these concerns, we can say that the panchayats today are rising when we see that timely elections are taking place, financial devolution is taking place, more women representation is coming, but still we have the issues like Pati Panchayat, which are also getting minimized because of the educated and the capacity building which is happening in the society via the behavioral revolution. And the prime example we can take note of that is the central parliament reservation bill for the women, which is going to uh, implement post the delimitation commission report comes into the picture, and that will aid the process of more uh, डिसेंट्रलाइजेशन इन इंडिया एंड अर्बन लोकल बॉडीज की अगर हम बात करें तो अर्बन लोकल बॉडीज के अंदर हम एग्जांपल भी ले सकते हैं अभी का दैट दिल्ली म्यूनिसिपैलिटी एंड चंडीगढ़ म्यूनिसिपैलिटी ऑफ रो विच इज गोइंग ऑन इनटू द सुप्रीम कोर्ट इनटू द हाई कोर्ट्स, जिसके ऊपर देखने को यही मिला है कि जो करप्शन है दैट इज अ मेजर कंसर्न इनटू द अर्बन लोकल बॉडीज. नंबर टू, देयर इज अ कॉर्पोरेट एंड पॉलिटिकल नेक्सस जो कि पहले एमएलए एमपी के टाइम पर होता था, अभी वो अर्बन लोकल गवर्नेंस में भी होता है. जब हम बात करते हैं रियल स्टेट कंस्ट्रक्शन होता है उसमें ज्यादा पैसा खाते हैं अर्बन लोकल बॉडीज वाले. इसके अलावा जो अर्बन लोकल बॉडीज हैं उनका अपना जो कैडर है उसमें भी हम देखते हैं कि मोस्ट ऑफ द जो वैकेंसीज हैं वो अनफिल्ड रहती हैं, तो उनका भी टाइमली फुलफिलमेंट होना चाहिए, अपॉइंटमेंट होनी चाहिए. और सोशल ऑडिट का मैकेनिज्म यहाँ भी होना चाहिए, ग्रीवियंस रिट्रेशल बॉक्सेज होने चाहिए ताकि जो अर्बन लोकल बॉडीज हैं उनसे आप ग्रीवियंस उनको दें और टाइमली उसका सेटलमेंट हो. और अगर दिल्ली की बात करें तो वी हैव अ फेमस स्कीम विच इज जस्ट लॉन्च कि आप जो है एक सोशल मीडिया के ऐप से अपनी ग्रीवियंस को रजिस्टर करा सकते हैं, बट वी रिक्वायर अ डिजिटल सेंट्रलाइज पोर्टल ऑफ अर्बन लोकल बॉडीज जहां पर आप इन सारी चीजों को डील कर सकते हैं. तो किसी को कुछ बोलना है तो आप बोल सकते हैं इस क्वेश्चन के ऊपर. What is the division of powers between center and state under the Constitution of India? Discuss whether the grant of greater authority to states would be in the interest of strengthening the integrity and promoting the economic development of the country. तो डिवीजन ऑफ पावर जो है हमारे यहाँ आर्टिकल 246 बताता है, 7 शेड्यूल बताता है. इसके अलावा जो पार्ट है, पार्ट 9, पार्ट 11 और पार्ट 12, जिसके अंदर बताया गया है कि एडमिनिस्ट्रेटिव रिलेशंस क्या होंगे सेंटर स्टेट के, फाइनेंशियल क्या होंगे और लेजिस्लेटिव क्या होंगे. तो डिवीजन ऑफ पावर एग्जैक्टली किया गया है. इवन जो जुडिशरी है उसका भी सेपरेशन ऑफ पावर मेंशन है. कि स्टेट के अंदर काम करने वाली हाई कोर्ट किस तरीके से काम करेगी और सेंट्रल लेवल पर जो सुप्रीम कोर्ट है वो किस तरीके से एज अ कॉन्सिलिएटर काम करेगी दोनों गवर्नमेंट के बीच में और डिवीजन ऑफ पावर को इंश्योर करेगी बाय इंटरप्रेटिंग द कॉन्स्टिट्यूशन इन इट्स ट्रू स्पिरिट. There should be a harmonious balance in granting authority to the states, because we have seen that in Indian context, mere granting of more authority does not necessarily result into the national integrity and economic development. In most of the instances, it leads to regional patriotism, which becomes a great concern for the national patriotism and in the integrity and sovereignty of the country. Example we can take of Punjab. If the Punjab as a state will be given more power over the controlling of border and over the police management, so it might create some concerns for Indian security, and that is why we have the BSF 50 kilometers jurisdiction extension norm, which is implemented by the MHA. Apart from that, it is true that economic development and integrity happens when you devolve, but it is not only when you devolve authority to state. You have to devolve authority to panchayats also, to tribunals also, to local bodies also, to cooperative societies also. So in India, every institution shows the pluralistic nature of development. जब हम बात करते हैं एनजीओ को, तो एनजीओ को भी पावर देना उतना ही जरूरी है. तो एनजीओ को पावर देने से भी इकोनॉमिक डेवलपमेंट होता है, लेकिन उसमें भी हमारे यहाँ रीजनेबल रेस्ट्रिक्शन है. तो कहीं ना कहीं हम बोल सकते हैं कि ग्रेटर अथॉरिटी स्टेट को दी जाए, उससे जरूरी नहीं है इंटेग्रिटी या इकोनॉमिक डेवलपमेंट आती है. किन चीजों से आती है? जब आप ग्रास रूट डेवलपमेंट को प्रमोट करते हैं, जब आप बेसिक सोशल एक्सपेंडिचर के ऊपर पैसा लगाते हैं, जब आप सोसाइटी के अंदर इनइक्वालिटी और इनजस्टिस को प्रमोट ना करके उसको रिड्यूस करने के इफेक्टिव स्टेप्स लेते हो, जब आप अपने जो स्ट्रक्चरल स्ट्रेंथ है जैसे कि आपकी पार्लियामेंट है उसके अंदर आप इफेक्टिव पार्लियामेंट्री सेशन चलवाते हो, जब आपके यहाँ जितने भी कॉर्पोरेट सेक्टर है वहां पर सन ऑफ सोइल थ्योरी के हिसाब से अपॉइंटमेंट नहीं होती है, वहां पर जो है आपका मेरिट के बिहाफ पर इम्प्रूवमेंट अपॉइंटमेंट होती है. तो इन सारी चीजों से हम बोल सकते हैं कि इकोनॉमिक डेवलपमेंट और इंटेग्रिटी बनती है रादर की खाली स्टेट को ही पावर देने से बने. तो औशिक, आप कुछ बोलना चाहेंगे इस क्वेश्चन के ऊपर?
No, Pravesh, you can continue.
ओके.
Grant of greater authority to states. When we say that, that doesn't mean giving power to the states at the cost of center. It is only saying that grant of greater authority to states. So you can always bring those areas where there must be greater authority with the states. Even if they are already having control over certain areas and certain functioning as per the schedule 7 and so on, still you can always categorize whether it is animal husbandry, whether it is interstate, agriculture marketing produce, because it is saying strengthening the integrity and promoting the economic development. So do not bring examples like we discussed of Punjab border area and all that. There are so many other areas also. Center had just given lot of, I shouldn't say a lot of, but a huge grant for promoting district education institutes, thereby creating centers of excellence, and especially in the scheduled and non-scheduled languages. Now, this is also one of the ways to promote economic development, because if education will be strengthened, then at the end of the day, employability will be increased. So always bring soft power idea. Always try to bring how to facilitate, for example, whether it is MG Narega or whether it is another kind of scheme. So you will be getting more marks because the question will try to trap you. And as far as regional patriotism and national patriotism is concerned, none of the states in India ever had any such tendencies. Political powers may be having tendencies, but not the people. Thank you.
Welcome, sir. So now we have the question, what is the purpose of having a concurrent list in the Constitution of India. So as we know that 7th schedule provides 3 types of lists: union, central and concurrent list. So concurrent list का पर्पस ये है ताकि जो पेक्यूनरी इंटरेस्ट है अगर वो आ जाए किसी मैटर के ऊपर, अगर लार्जर सोसाइटल इंटरेस्ट की बात करनी हो तो पार्लियामेंट उस चीज को डिसाइड करे। और पार्लियामेंट ही क्यों डिसाइड करे? क्योंकि पार्लियामेंट के अंदर दोनों चीजों का रिप्रेजेंटेशन है। वेरी फर्स्ट इज द every citizen of India is represented by the Lok Sabha when we talks about the constituencies, and second we have the states representation also in the parliament in the form of Rajya Sabha. So parliament has the power to make laws over the concurrent list in 2 cases. Number 1, when there is no law made by the state in the concurrent list, and number 2, when the state government has already made a law under the ambit of concurrent list, then also that law can be subject to the overview and jurisdiction of the parliamentary law. अगर हम बात करें कि ऐसे कौन से मैटर्स हैं जिनके ऊपर कॉन्करेंट लिस्ट के अंदर उनको डाला गया ताकि जो स्टेट्स और जो पार्लियामेंट इंटरेस्ट है, पार्लियामेंट्री इंटरेस्ट को ऊपर रखा जाए स्टेट्स के इंटरेस्ट के। फॉरेस्ट, हम बात करते हैं फॉरेस्ट राइट्स एक्ट जिसके अंदर 33% रिजर्वेशन की हम बात करते हैं, फॉरेस्ट एरिया होना चाहिए। So why parliament is talking about the forest in the concurrent list? Because already when we were saying that forest was a part of state list, what was the need to bring into the concurrent list is to have the larger forest coverage across the India and do not allow any state governments to focus more on development as compared to the environment and the ecological part. Number 2, education. आज के टाइम पर भी हम बात देखते हैं कि the education system in India is not as competent when we talk at the grassroots level. पर्ची सिस्टम आज के टाइम पर भी चलती है, चेकिंग्स आती है, उनकी जेब के अंदर पैसे डालकर चेकिंग को भी बाईपास कर दिया जाता है। तो we have the stringent laws which are coming from various states across India, लेकिन जब पार्लियामेंट उस चीज को इंप्लीमेंट करेगी तो सेंट्रल एजेंसीज जो है उसके ऊपर बेटर रेगुलेट कर सकती हैं। उसके अंदर जो मेरिटोरियसनेस है वो कहीं ना कहीं लार्जर स्केल पर अपहोल्ड हो सकती है, और जो एजुकेशन एज अ प्रिंसिपल है उसके अंदर कहीं ना कहीं पार्लियामेंट जो है वो अहम भूमिका निभा सकती है। जब हम बात करते हैं नेशनल एजुकेशन पॉलिसी, जब हम बात करते हैं एजुकेशन के अंदर स्टैंडर्ड्स देना वाया एनसीईआरटी, आईसीएसई बोर्ड, जब हम बात करते हैं हैकी की, हायर एजुकेशन काउंसिल ऑफ इंडिया, जो कि रेगुलेशन भी करती है, फाइनेंसिंग भी करती है, एडमिनिस्ट्रेटिव कंट्रोल भी रखती है ऑल द यूनिवर्सिटीज का, चाहे वो मेडिकल यूनिवर्सिटी क्यों ना हो, चाहे वो लीगल यूनिवर्सिटी क्यों ना हो। इसके अलावा भी और हमारे यहाँ 5 से 6 एरियाज हैं जहां पर कॉन्करेंट लिस्ट के अंदर मैटर डाले, जो कि हमने पहले भी बात की: एजुकेशन, फॉरेस्ट, वाइल्ड एनिमल्स एंड बर्ड्स, वाइल्ड लाइफ प्रोटेक्शन एक्ट 1972। जब हम बात करते हैं वाइल्ड लाइफ प्रोटेक्शन एक्ट की तो अलग अलग स्टेट्स आल्सो पोज सम कंसर्न इन द वाइल्ड लाइफ प्रोटेक्शन एक्ट दैट व्हाई द chief wildlife warden will take all the decision. Why not our forest personals which have been appointed by the state services? They do not enjoy the similar kind of powers, again to uphold the larger principle of the environmental conservation, and that is why the parliament has been given such powers over the state list in the concurrent matters, and that is the wildlife, animals and birds. Apart from that, administration of justice, like constitution of all courts like Supreme Court, High Court, how they will be constituted, how the matters, how, for an example, public prosecutors, every state government has the full right to appoint public prosecutors according to the exams which they take, but the parliament has made a law that public prosecutors will be appointed on the basis of a centralized exam will be conducted by the Union Public Service Commission. Why so? Because already when we are seeing that there is the concerns of corruption into the lower judiciary raised by the various legal luminaries of the country, we cannot allow that the ADR mechanism, alternative dispute resolution mechanism, of which efficacy depend on 2 principles only: impartiality and affordable justice to the people, to the common man. So if the states will be given such powers, so there are chances that the corruption, and we are not associating it with the state, that only the state government can do the corruption, but there are chances that some kind of standards, such kind of central standards will be absent, will not be as efficient when we're talking about the parliamentary procedure, where the UPSC is conducting the exam of the PP, and then the public prosecutors are trying to entertain the common man of the country so that they also get the due justice in the country.
That is
So we can
why
say,
that is why you can say that administration of justice, constitution and organization of all courts, and even criminal law, or when we say all courts except Supreme Court and High Court, that is coming in the concurrent list. And in case of criminal law, all the matters including IPC, excluding naval, military, or armed forces and so on. So rather than saying that state cannot put the standards, we can also say the diversity and the unique nature of the Indian setup. Because you have to remember that in case of concurrent list, what is most important is the uniformity is desirable, but not essential. Uniformity is desirable, but not essential on the items in the concurrent list. And the main goal is that if any provision of law is made by the legislature of a state, which is repugnant to any provision made by the parliament, over which parliament is having the power to enact a law, then in such context you can say when the law will be made by parliament or whether it is already passed by the parliament, then the state law will not be coming into existence. There may be certain exceptions, but then this is the whole point. That is why concurrent list is very important. Bankruptcy, insolvency, contracts, marriage and divorce, then forest, as you just said, protection of wildlife and animals. Always remember that forest and wildlife, weight and measures, administration of justice, education, they all came through the 42nd Amendment Act 1976. There were 5 subjects which were transferred from the state list to the concurrent list. Thank you.
thank you, sir. So now the last question we have, which is talking about what are the objectives in having 3 separate legislative lists in the Constitution of India? Can the Parliament make in regard to any terms in the state list? If so, then understand separation. Does any of the issues arising from the state union, state controversies? I think there is a mismatch in the sentences. So in brief, what we can say that what are the objectives in having 3 separate legislative lists in the Constitution of India? So number 1, when we are talking about Article 1 of Indian Constitution, Article 1 saying that India is a federal country, but when we interpret this federalism, that is the quasi-federalism, where the center is having strongest tendencies to ensure that Article 1 remains in power. Article 1, which is talking about the unity and integrity and sovereignty of the country, do not harms via any interest. So Article 1 जो कि कंट्री की यूनिटी, सोवरेनिटी, इंटेग्रिटी को बचाने की बात करता है और जो कहता है कि जो फेडरल सिस्टम इंडिया का है वो क्वासी फेडरल है, जहां पर सेंटर के पास ज्यादा पावर है. ये हुआ पहला रीजन जिसकी वजह से हम जो कहते हैं कि ये एक ऑब्जेक्टिव है जिसकी वजह से हमारे यहाँ सेपरेट लेजिस्लेटिव लिस्ट कॉन्स्टिट्यूशन के अंदर दी गई. दूसरा, अगर ऐसा है तो क्या सेंटर ही सारे काम करेगी? नो, देयर विल बी अ सेपरेशन ऑफ पावर, जिसके अंदर फर्स्ट टीयर गवर्नमेंट भी कुछ कर सकती है, सेंट्रल गवर्नमेंट 97 सब्जेक्ट्स इन द यूनियन, स्टेट कर सकती है 66, कॉन्करेंट के अंदर दोनों कर सकते हैं. इसके अलावा ऑब्जेक्टिव क्या है? फंक्शनल स्पेशलाइजेशन, यानी जिसका काम उसको साधे. आपके कुछ ऐसे काम हैं जहां पर आपको यूनिफॉर्मिटी चाहिए, सेंटर करेगी. आपके कुछ ऐसे काम हैं जहां पर रीजनल स्पेसिफिक आइडेंटिफिकेशन चाहिए, ज्योग्राफिकली, लिंग्विस्टिकली, रिलीजियस कस्टम्स के हिसाब से चीजें होनी चाहिए, तो इसमें आप स्टेट करो, इसमें सेंटर नहीं करेगा, आपको ओवरव्यू करेंगे. इसके बाद, कैन द पार्लियामेंट मेक law in the state list? Yes, under 5 conditions: national emergency, president rule,